Welcome to the deep dive. Today we're looking at some, well, frankly, quite demanding source material. We're plunging into the ancient legal systems, mostly Roman and Greek, and specifically we're looking at the harsh realities of status and control. How did these systems define who is even a person? It's often pretty shocking stuff compared to how we think today. Our mission isn't just to say slavery existed. We want to unpack the really complex, sometimes brutal legal thinking behind it all. Who was property? Who is basically a legal non-entity? And how did this whole ownership thing play out in the courts, in society? We'll kick off with Rome's intense focus on property law. Then we'll jump over to Athens to see a very different system, one based on citizenship, procedure, and, well, public arguments.
Yeah, and to really get the Roman side of things, you have to start with the absolute foundation. The slave, the service, was legally rizal, a thing, property. Now, this wasn't about morality for them, not in the legal sense anyway. It was just a cold, hard legal category. And it dictated pretty much everything, their economic value, whether they could make a contract, what happened if they were injured, their complete lack of legal standing. This definition, slave equals property, it's the engine driving all the weird legal situations, the paradoxes we're going to talk about. I mean, think about it. Your legal system defines a human being as an object somebody owns. You then have to invent some incredibly complicated rules to handle what happens when that object gets involved in contracts or crimes or even family relationships. It's a system built, first and foremost, to protect property. That's what we need to understand.
Okay, so let's really unpack that core idea, the legal non-person. The slave's life completely dominated by the potestas, the power of the master. But you mentioned something crucial. The sources often lump slaves in with other family members, legally speaking.
That's right, and it's critical to get that straight away. Obviously, the consequences were way, way worse for the slave, but the basic legal concept of being under power in potestate also applied to a wife in manu, or a son still under the paterfamilias, the male head of the household. Roman legal writers, when they're talking about legal incapacity, they often just list them together.
Yeah.
Wives, sons, slaves.
And what was the common thread? What legally stripped them, wives, sons, slaves, of their ability to, say, sue someone or make a binding contract on their own behalf?
The reason the tests give is brutally simple. It's because, and I'm quoting the logic here, since these persons can own no property, neither can they reclaim anything in point of justice. No property capacity. If you literally cannot own assets, you can't have a legal interest that a court can recognize or protect against anyone else, not even against your own father or master. It's like a closed loop. Your powerlessness stems directly from not having property rights.
So the slave can perform an action, make a promise maybe, but legally they're just acting like an extension of the master.
Exactly. A pure legal instrument for the master's finances. The clearest example is stipulation. That's a formal type of oral contract in Roman law. If a slave makes a stipulation, maybe promises something or agrees to receive something, the obligation, the legal right or duty created, it's acquired immediately, but it's acquired for the person who holds potestas over him, for the master.
Instantly. The slave does the talking, but the legal effect, the money or the right, just bypasses them and lands straight with the master.
Precisely. The jurors get quite technical about it. They say the obligation for a certain moment does not stand vested in the person through whom it is acquired. It's their way of saying, okay, the slave's mind is involved enough to make the agreement happen, but their legal identity is so thin that the actual acquisition jumps right over them. Yeah. They're just the messenger, really, and the message goes straight on to the master's books.
Wow. And this applied even to something as fundamental as inheritance. It seems, well, contradictory that property could inherit property.
It does seem contradictory, doesn't it? But it served the household's economic continuity. A slave could actually be named as an heir in a will, either straight up or maybe conditionally. Like the will might say the slave is ordered to be free if he had given 10, presumably sesterces or some asset, before the 1st of December.
So the slave is acting like a temporary manager or placeholder?
Sort of, yeah. A functional executor. It's a mechanism to ensure things get done, debts paid, assets managed before the main inheritance passes on, maybe to the master's son. It ensures the estate functions smoothly during the transition. It's about managing the estate's assets effectively.
That really shows just how deeply embedded enslaved people were in the whole system of Roman wealth and how it passed down generations. But you mentioned it gets even more fiddly when a slave is owned by more than one person, the common slave.
Oh, the rules for common slaves are, they're some of the most precise, almost painfully logical examples you'll find. They really want zero ambiguity about property rights. So, imagine a slave owned jointly by Master A and Master B. Maybe this slave manages a peculium,
Right, that's like a pot of money or assets the master lets the slave use for business, but it still legally belongs to the master.
Exactly. Now let's say this common slave makes a contract, a stipulation, using funds from his peculium. And we know that peculium was provided only by Master A.
Okay, so who gets the benefit of that contract? Both masters?
Nope, only Master A. Even though Master B owns half the slave, he gets nothing from that specific deal because the underlying money, the peculium, belongs solely to Master A. It shows that the legal right follows the asset, not the slave who's just the go-between.
All right. What if the deal involves something else? Say, the common slave makes a stipulation to acquire another slave who will also be owned jointly by A and B.
Then it gets even more abstract. The jurists decided that one stipulation is treated as two separate obligations. It's as if the common slave momentarily splits into two legal personalities, one acting for A, one for B. And the obligation is only valid for the master, who actually have the legal capacity to acquire that specific thing or share. Well, it's a stunning level of legal fiction, isn't it?
Yeah.
Treating one person as two distinct fractions just to make the property accounting work perfectly.
Incredible. Okay, moving from acquiring things to gaining freedom. Manumission. You said freeing a slave didn't always mean full freedom or citizenship,
Yeah,
especially if it was done informally.
that was the catch. Roman law had very strict, formal ways to free a slave under the old civil law, the Ameria Civil. If you did it informally, maybe just declared them free in front of friends or wrote a letter, then under that strict civil, they technically remained a slave. They lived freely. Nobody treated them as enslaved day to day, but they didn't have the rights of a citizen under that old law, which, as you can imagine, created a huge problem.
A legal limbo. And this is where we see that tension you sometimes get in Roman law between the really old, rigid rules and, well, a more pragmatic approach.
Exactly. The tension between the aegis civil, the ancient formal law, and Praetorian law, the law developed by the praetor. The praetor was the top legal magistrate, and his job included the power to aid, supplement, or correct aegis civil. So when faced with all these people living free but technically still slaves under the old law, the praetor had to step in.
Why? Was it a moral issue or just practical?
Mostly practical, I think, though you could argue there's an element of fairness, what the Romans called equitus. Having potentially thousands of people in this uncertain status was just messy. It could cause social unrest, undermine contracts, and generally make people doubt the justice system. So the praetor offered protection in a framework of freedom. He couldn't change the equitus civil, but he could use his own authority to make sure these informally freed people were treated as if they were free in his court. It created a sort of parallel status, protected by the magistrate, even if the old law hadn't caught up. It's a classic example of Roman law evolving through practice.
And once someone was properly freed, what was the ongoing tie to their former master, this patron-freedman relationship?
It was a permanent relationship called patronage. The freedman, the libertus, owed certain duties, maybe performing some services, showing public respect to their former master, now their patron. But, and this is important, the law limited how long this lasted, across generations. The patron's rights as patron could pass down his family line, usually through the male side. But the freedman's duties did not pass down to his children.
Ah, so it wasn't a permanent state of obligation for the freedman's entire family forever?
No, exactly. It prevented the relationship from turning into a kind of inherited second-class status. The specific bond faded out after the first generation.
Okay, so we've seen how status shaped contracts and freedom. How did this property status play out when things went wrong, crime, injury? You mentioned a strange situation where an owner could technically steal his own slave. How does that work?
Right, this really gets to the heart of what theft meant in Roman law. It wasn't always about proving who had the ultimate ownership title. Often it was about interfering illegally with someone's legitimate possession of the thing.
So when could an owner be accused of stealing their own slave?
It typically happened if the slave was legally in someone else's possession for a specific reason. Say a creditor was holding the slave as a pignus, that's a pledge, like collateral for a loan. Or maybe someone else had a usufruct over the slave.
A usufruct, what's that?
It's the right to use something and take its profits, or products in this case, the slave's labor, even though you don't own the thing itself. The original owner still has the title, but the usufruct holder has the right to the slave's work for a period.
Got it. So if the owner secretly took the slave back from the creditor holding the pledge or from the person with the usufruct?
Exactly. If the owner took the slave back without permission, against the will of the person legally possessing them, then that possessor, the creditor or the usufruct holder, could sue the owner for theft.
Wow. So the law protected the possessor's temporary economic right even more strongly than the owner's ultimate title in that moment. It's really about protecting the economic expectation, isn't it?
Absolutely. It shows theft was often about the disruption of a valid economic interest held by the possessor. And that same logic applies to why a master couldn't sue his own slave for theft.
The impossibility of self-theft.
Right. A master couldn't bring a theft action against his own slave, nor could a father sue a son who is still in potestate. The legal thinking is stated very directly. A man can no more sue a person subject to his potestas than he can sue himself. Legally, the slave or the son in power is considered part of the master's or father's legal and economic identity. They're not separate legal persons capable of stealing from that identity.
Hold on. So if a slave steals something valuable from the master and is then freed or sold a week later, does the crime just vanish? Can the now former master not sue the now freedman for the theft that definitely happened?
Legally, yes, the original crime is nullified. The sources are clear. You can't prosecute later for something that happened when the legal relationship made prosecution impossible. If a slave committed theft against his master and was then sold or manumitted, no action for theft could be brought against him for that specific act. The reasoning. Because no action was possible at the time of the act, the slave was part of the master's legal unit. No action can magically arise later, even if the slave becomes his own legal person.
It seems to prioritize the legal structure, the potestas,
Yeah.
over punishing actual wrongdoing.
It does. It really shows how committed the Roman legal system was to the internal logic of its own status definitions. If the law said the act wasn't legally possible then, a change in status later couldn't make it retroactively possible. But, and this is the key difference, if that same freedman commits a new act of theft after being freed, then he is liable, because now he's a separate legal person, capable of committing an actionable offense against his former master or anyone else.
Okay, let's switch to physical harm. If someone damaged or killed a slave, that fell under the lexikilia, the law on damage to property. How did they figure out the compensation? How did they value a slave's life or limb?
This is where the property logic is just laid bare, really starkly. When assessing damages for killing a slave, the court was explicitly told, look at the general market value. Do not consider personal feelings.
Why make a point of excluding personal feelings? Seems obvious if it's property.
Well, the jurist who lays this out gives a really telling example. He says the judge must ignore the fact that the slave who was killed might have been, say, the owner's own natural son, whom the owner loved and would have redeemed for a great price.
Ooh.
Irrelevant. The court must only consider what he would be worth to the world at large, the market price.
That's quite something. It's like the law actively pushes back against acknowledging any human connection or emotional value. It has to reinforce the thingness of the slave.
Precisely. Allowing emotional value would crack the facade. It would admit the slave was more than just an asset, which could undermine the whole legal basis of slavery. So the law sticks rigidly to objective, measurable economic loss based on market value.
What about complicated cases? Say a slave is attacked by two people, one wounds him badly, looks like he'll die for sure, then the second attacker strikes a blow, and the slave dies, maybe sooner than he would have otherwise. Who's liable?
The classic causation problem. Roman jurists thought about this a lot, and their main goal was always ensuring the master got compensated for his lost property. The basic principle was, anyone who provides a cause of death in any way is considered to have killed.
So in that scenario, the first wound was fatal, the second just sped it up.
Under the lexikilia, both attackers could be held liable for killing. The second attacker isn't off the hook just because the slave was already dying. By hitting him again and causing death sooner, they are seen as having provided a cause of death.
Yeah.
And if it was genuinely impossible to tell which blow was the fatal one, the jurists tended to say, well, hold them all liable. The priority was making the master whole for the economic loss. Someone destroyed his asset, and someone's going to pay.
Okay, last point in this section. Non-fatal harm, like insults or beatings. We heard the law admitted slaves feel things, but how did that square with them being property?
Yeah, there's a definite tension there. The law made a distinction. Was the insult or outrage aimed at the master, using the slave as a proxy? For instance, publicly humiliating a master's slave to damage the master's honor.
Okay, in that case.
The master could bring an action for insult in his own name for the damage to his reputation.
But what about the harm done to the slave? The feeling of the beating itself?
This is where you see a flicker of recognition. The jurists actually said that an outrage done to the slave as such shouldn't just be ignored, specifically, for it is obvious that the slave himself feels such things. It's a surprising little crack in the dehumanizing logic.
But I bet that flicker didn't last long. Was it immediately qualified?
Almost instantly.
Yeah.
The very next thought is usually the massive exception. If someone beat a slave by way of correction or reform, they weren't liable. Masters had huge leeway to use violence to discipline their property. You'd only be liable for beating if it was done contrary to sound morals, suggesting it had to be really excessive, sadistic, totally beyond any claim of discipline. The default assumption was that violence was part of managing the slave.
Right, and it's worth just hammering this home again. This concept of potestas, this lack of independent legal capacity, it wasn't just about slaves. It covered the whole Roman family unit under the paterfamilias.
Absolutely. We mentioned sons in potestate. If a son still under his father's power committed a crime that caused harm or loss, the lawsuit was against the father. The father was responsible for the actions of those under his control. And just like a master couldn't sue his slave for theft, a father couldn't sue his son in potestate for theft either. It reinforces that the household was seen as this single legal and economic unit controlled from the top.
It sounds like a system designed to keep all the internal family conflicts, the financial dealings, completely private and under the authority of the head of the household, maintaining stability above all.
That's a good way to put it. It preserved the legal unity and the father's authority. But even this rigid system had to bend sometimes, especially when it ran up against really basic moral norms, like around marriage and incest. Roman law had strict rules about who you couldn't marry, based on morality, and these applied even after someone was freed.
And these rules actually recognized relationships that existed while people were enslaved. That seems like a major departure from the slaves or property rule.
It is. It's where the legal fiction starts to break down against what they called natural law or just basic decency. The law explicitly said that blood relationships or marriage-like ties formed while people were slaves still counted as legal barriers to marriage after they were freed. So, for example, a man freed from slavery could not legally marry the woman who was his mother or his sister during slavery.
But legally, how could property have a mother or sister? Weren't those ties legally meaningless before freedom?
Legally, yes. But here, the Romans appealed to a higher standard, initus natural law, and fundamental morality. They give the example of a natural father and his daughter. Even if she was born while he was a slave or born out of wedlock and then later freed, he still couldn't marry her. And the reason given isn't about property or status, it's purely moral. It is indecent to make a daughter into your wife.
So even Rome's incredibly formal, property-obsessed legal system had limits. It had to acknowledge certain fundamental human relationships, even if its core logic tried to deny them. Economics ruled most of the time, but basic kinship taboos were too strong to ignore. Okay, we've spent a lot of time on Rome's very rigid property-based system where your legal standing depended on who owned you or whose potestas you were under. How did things look in Athens, a place built on democracy, citizen participation? How do they handle status and justice?
It's a completely different world, legally speaking.
Yeah.
In democratic Athens, the key dividing line was citizenship. Being a citizen gave you the right to participate in the assembly, in the courts. Status wasn't primarily about private power, like the Roman paterfamilias. It was about your public role in the polis, the city-state.
So what did being a citizen mean, practically, in legal terms?
Well, one huge consequence was economic. Generally, only a full citizen could own land in Attica, the territory around Athens. The land itself was seen as fundamentally belonging to the community of citizens, the polis. This automatically put non-citizens, even wealthy resident aliens called medics, at a big disadvantage.
If a medic couldn't own land, how did that impact things like finance or big projects?
Land was the best, often the only, security for large loans. So if a medic wanted to lend money or invest heavily, they usually needed a citizen partner who could legally hold the land title as collateral. And think about major resources, like the silver mines at Laurion. Those were considered community property owned by the polis. Concessions to operate them, almost never granted to non-citizens. The wealth of the land was reserved for the citizen body.
That's a really stark contrast to Rome's focus on private property rights being paramount. And you mentioned Athenian legal culture was very competitive, adversarial, and an agonistic culture. Deeply agonistic, yes. It grew out of older Greek traditions where honor was everything. A core idea was that you had a moral duty to help your friends and harm your enemies. And the law courts became a prime venue for doing exactly that. So bringing a lawsuit wasn't necessarily seen as this impartial search for truth. Often it was just one move in a long-running feud between individuals or families.
Going to court was about defending your honor in public. And not retaliating if someone wronged you was seen as weakness.
Absolutely. It was a public performance. You had these huge juries, hundreds of citizens watching. Winning a case wasn't just about justice. It was about publicly defeating your enemy, enhancing your own reputation and status within the community. It was intensely personal and competitive.
And because you had to persuade these massive juries, public speaking skills became incredibly important, essential. In a radical democracy like Athens, if you couldn't speak persuasively, you couldn't succeed politically, not in the assembly and not in the law courts either. This led to the rise of rhetoric as a profession. You had professional speechwriters, logographers, who'd craft arguments for citizens to deliver. Language itself, how to persuade, became a really big deal, a hot topic, as one scholar put it.
I remember reading about plays like The Oresteia, where the whole point seems to be showing how the establishment of law courts replaces bloody vengeance cycles, a kind of civic mythology being built.
Exactly. The law court is presented as the polis's tool for managing conflict peacefully. But even with that ideal, the Athenian system kept this very procedural, sometimes almost arbitrary feel. Which brings us to what you call the aha moment, the paradox of penalty.
Yeah, this is the bit that feels really alien to modern thinking, where we expect the punishment to fit the crime, right? But in Athens, often the procedure chosen determined the punishment, not just the offense itself.
Probably the most shocking feature for us. It really highlights the difference between a system trying to apply objective rules, like Rome often did, and Athens's participatory, tactical system. The actual offense, let's say, corruption by a magistrate, could be exactly the same, but the penalty could be wildly different depending purely on which legal path the prosecutor decided to take.
Okay, break that down. What were the options for prosecuting a corrupt official, and what were the potential outcomes?
Right, so take magisterial corruption. If the prosecutor wanted to go for maximum political impact, a really serious charge, they might use a procedure called isengelia. This is like a form of impeachment, often used for treason or major offenses against the state itself. If they brought an isengelia and won, the punishment might be death. It was a heavy political weapon.
But they didn't have to go that route. They had tactical choices.
Exactly. Maybe the prosecutor wasn't aiming for the official's head, but wanted serious accountability after they left office. They could use the euthuni procedure that was a standard review of a magistrate's conduct. If found guilty of corruption there, the penalty might be, say, a fine equal to 10 times the amount mishandled. Still serious, but focused more on financial penalty and public censure.
Okay. And what if the main goal was just getting the stolen money back for the state?
Then they might opt for an apography. This was a procedure specifically designed to identify and recover state property that had been illegally appropriated. If the prosecutor used this route, the corrupt official might end up just having to pay back the bribe or the stolen funds, maybe with confiscation, but without the huge fine or political death sentence of the other procedures.
That's just staggering. Death, a massive fine, or just giving back the loot for the same basic act of corruption. It really shows the system wasn't focused on finding one correct punishment. It was about the civic contest, the prosecutor's strategy, wasn't it?
Completely. It highlights just how procedural and tactical Athenian justice could be. The citizen prosecutor literally had a menu of options, and their choice set the potential penalty. It reflects the polis allowing its citizens to decide what the priority was in any given case. Political annihilation, financial restitution, simple recovery. That flexibility is just worlds away from the Roman focus on fixed legal statuses and liabilities tied to property. Hashtag outro way.
So we've really covered some ground here. From Rome's incredibly structured legal world, where being a person was almost entirely defined by property law and the power of the paterfamilias, all the way to Athens, where justice felt more like a public contest, status came from citizenship, and even the punishment could depend on which legal game you decided to play.
The difference in outlook is huge, isn't it? Roman law is about control, largely through private property rights and the defined power structures within the household. It ends up treating people as assets, with incredibly detailed rules for managing those assets. Athenian law is much more about access and participation, who gets to be part of the polis, who gets to use the legal tools. And the outcome could hinge on public persuasion and procedural choices.
But in both systems, you see the immense power of the state or the legal structure to simply define what a human being is worth, legally speaking. They drew these hard lines, person versus thing, citizen versus outsider.
Absolutely. And reflecting on that, especially the Roman side, maybe leads to a final thought for you, listener. When you see just how much detailed, complex, sophisticated legal thinking went into managing human beings purely as property, defining their value if injured, figuring out who gets their labor if they're co-owned, deciding if they can even be stolen from themselves. What does that history tell us about the value of personal liberty? Something we tend to just assume now as fundamental, non-negotiable. How fragile is that status, perhaps, when legal systems are built primarily to protect property or maintain economic order or uphold power structures, maybe above the inherent value we now assign to just being human? It makes you realize that the line between being a person and being property isn't necessarily a natural one. It's a legal line. And history shows us that line can be drawn in some pretty terrifying places.